Good afternoon and welcome to the North Carolina Court of Appeals. Your panel this afternoon is to my right, Judge Toby Hampson. To my left is Judge Julie Flood. Our courtroom clerk today is Eddie Saunders, and our marshal's Tom Salou. Thank you for being here. We have two cases on the docket for argument this afternoon. The first one is State versus Harvell. The court had issued an order on oral arguments in this case to help direct the parties on the issue the court was interested in. And the order said whether or not the state presented sufficient evidence of defendant's attempt to obtain a quote-unquote thing of value within the meaning of North Carolina General Statutes 14-100A. So are there any preliminary matters to come before the court? Okay, well, in that case, we will hear from the appellant. Good afternoon.
May it please the court. I am Karen Strickland, and I represent Nicholas Harvell. I would like to reserve 3 minutes for rebuttal, please. Okay. The trial court erred by denying the motion to dismiss the charge of obtaining property by false pretenses because there was insufficient evidence that Mr. Harvell attempted to obtain a thing of value. The indictment alleges that the thing of value that Mr. Harvell allegedly obtained was, quote, forgiveness of a debt of $4,500.
Do you agree that that forgiveness of a debt in the amount of $4,500, if there was evidence, sufficient evidence of it, would constitute a thing of value under the statute?
Yes, I think that would be a thing of value, not just under the definition of thing of value, but also under the definition of property, which was actually the term that was used in the jury instructions in this case. But our position is that there was insufficient evidence that Mr. Harvell actually owed a debt of $4,500.
Did the jury instructions identify what the alleged thing of value was?
I don't believe so. I think I just used the term property. So I think while technically the court could have instructed the jury on the specific thing of value that was alleged, the court chose not to do so here, and neither of the parties requested that instruction. But I don't think that that affects our sufficiency of the evidence argument, because there simply was not evidence of, well, the debt of $4,500, which is the property that was alleged in the indictment in this case, which is controlling. So taking all evidence in the light most—
Let me ask this, Ms. Strickland. Would even if the $4,500 was disputed, settlement of a disputed amount can be a thing of value too, correct? Even in a dispute?
I guess I would need to know what you mean by dispute, like in court, like if it was being litigated?
If the parties disputed something, disputed the debt was $4,500, one said it was one amount, one said it was another, and they resolved it, or they settled that, that would still be consideration to support a thing of value, correct?
So in the abstract, yes, with the caveat that I still believe that under the statute there would have to be some sort of underlying either court order or legally enforceable principle of contract. And I think it's very important that in this case, when the contractual principles that we're talking about concern child support, that is governed by statute, by NC General Statute 110-133. And in order to have an agreement that is enforceable in this context, it must be in writing, executed by a notary public, and approved by a judge. And so I think that it's important to stress that child support in general it's not like an ordinary contract, because there are statutory principles at stake in terms of what is in the best interest of the child. And so typically the law requires a judge to actually look at those factors, including what the child needs, and also the ability of the parties to give those respective amounts. And so I think the idea that you could have some sort of informal acknowledgement of debt or informal contracts, like my client saying, hey, I will give you this amount, is simply not enough to create a legally enforceable obligation such that it can be considered property or a thing of value within the meaning of the statute.
So if an offer was made, even on a disputed amount in dispute, and that was accepted by the other side, wouldn't that offer and acceptance form the basis of the agreement?
So in the child support context, I would say no. I would say that that would still be voluntary, and I think the Bible v. Creed decision from this court, which was affirmed by the Supreme Court, really speaks to that. In that case, the father was voluntarily paying child support over a course of years. The plaintiff had brought a child custody action, but not a child support action for 6 years. And the trial court ultimately, in looking at all those facts, made an equitable determination not to have the child support obligations run retroactively back to the date of the complaint. And I think all of that underscores the fact that while it is true in the abstract, we want people to support their children. That's an important public policy principle that we all agree
It's
with.
more than that. It's a legal obligation by virtue of being a parent, correct? It arises upon your status as a parent to support your minor children.
Right. I mean, I think that is true, that there is this legal obligation, but I think when you're talking about the meaning of property or a thing of value, these are statutory terms, and in interpreting them, not only do we apply canons of construction, but we also apply the rule of lenity, and we have to interpret these terms in favor of the defendant. I don't think that without a court order or a contract in this context, particularly when in this particular case, the only evidence about the paternity being established was in 2021, which was 3 years after the incident in this case. So I think that even if you reject my categorical argument that you must have a written agreement or a child support order, which I think is a correct statement of the law, but even if you reject that, the facts of this case, I think, would still make it so that there was no thing of value or property here, because there's simply no evidence that, I mean, all of the facts that the state points to in its brief, the paternity of the child was not established until 2021. Mr. Harvell had never previously paid child support. There wasn't some sort of situation where he acknowledged, hey, I'm really supposed to pay this, and then he stopped. And the only mention of child support court was after the incident in this case. So I think that even when you're talking in the abstract about a legal obligation, the facts of this particular case, I think, would take it outside of that general rule, even assuming that could apply.
So there's also evidence in this case that when they presented the check to be deposited, cashed, that the defendant was going to take some of the money from the proceeds in cash. There's also evidence that the day before he'd been given $100 for gas money, I guess. Why are either or both of those things not evidence of obtaining a thing of value?
So I guess I will start with, there's sort of
Or an
a
attempt to.
legal aspect of that, and there's a factual aspect of that. The legal aspect of that is that even assuming you are correct, and that is sufficient evidence of a thing of value, it's not the thing of value that was alleged in this case, because it doesn't show that there was a debt of $4,500. So I think that even if there was sufficient evidence of that, it would still, we cited in our memorandum of additional authorities, there's a case called State v. Mathis, and it's on page 282 of that opinion. The court discusses when the state is raising new arguments on appeal or there's other evidence, they look at what is actually alleged in the indictment. That is what's controlling, and that is because, and I'm sorry, they don't look at alternative theories that are outside of what's alleged in the indictment. And that is because the thing of value is actually an essential element of the offense that has to be alleged with factual particularity in the indictment. And that is in Brantley Phillips, which is cited in our brief, and also in the memorandum of additional authorities, State v. Jones and State v. Walston. They use the words reasonable certainty to describe the thing of value. And so if a different thing of value was proven, that still would not be sufficient to defeat a motion to dismiss in this context.
So is that language in the indictment, is that treated just as surplusage, or does it result in what you would contend is a fatal variance?
I think it would be a fatal variance. I don't think that it is surplusage. I think that the cases that we cited deal directly with, I think it's State v. Jones actually says this is an essential element, actually uses those words, it must be alleged with reasonable certainty. The case that the state cites, McVeigh, dealing with fleeing to elude an officer performing lawful duties, the particular lawful duties that are being performed are not really material to the core of the offense, which is whether the defendant was fleeing to elude. So I just don't think, this is not a case where this is surplusage. This is a case where it's an essential element, and the state is bound to the theory that it alleges in the indictment.
We've had a lot of litigation about what type of allegations must be in indictments.
Yeah.
And North Carolina's adopted short form indictments. And kind of puts the burden on the defendant to file a bill of particulars if the defendant is seeking greater specificity than that alleged in the indictment. That wasn't done here, was it?
No, and I don't think there would be a reason to do that here, because I don't think the complaint or the issue in this case isn't that there wasn't reasonable, specificity in the indictment of what was being alleged. The issue here is that the state just didn't prove what was alleged in the indictment, that there was a $4,500 debt that he owed. And I would also come back to the factual point of Your Honor's question. I think in the transcript, maybe there are things that can be picked out. I think they are very vague at best. I think that Ms. Atcher really didn't even testify with any specificity. So if there's this alternative theory that somehow this wasn't child support, that this was really money that she was supposed to give to him, she didn't say, well, how much was she going to keep? How much was he going to keep? The evidence of a misrepresentation seems to be lacking. But I also think it's just really important that throughout the witnesses, including the state's witnesses and the arresting officer, their theory was that this $4,500 debt was for child support. Officer Walter Archie testified, and this is at page 57 of the transcript, that Atcher came to him and said that the father of her child came to pay child support, but after she deposited the check, it bounced. So I think that it is very clear that that's what the state's theory was.
Let me ask you this. Is there a difference on writing on a check on an account with insufficient funds as opposed to writing a check on an account that has been closed?
From the perspective of the worthless check statute, or from the perspective of paying child support?
Really to show the intent, to show your client's intent.
Well, we're not disputing the worthless check charge. He was convicted of that. I think our concern is that this case was overcharged because there was essentially a duplicative charge saying that not only was this a worthless check case, this was also attempted obtaining property by false pretenses. And that's really what we dispute, is that in any case where somebody gives someone a worthless check, that is certainly a crime, and we're not disputing that. But that also shouldn't be proved to show that property was obtained.
And you don't see a distinction on a check written on an existing account with insufficient funds as opposed to a check written on an account that has been closed?
So I am not specifically aware of case law addressing that particular issue, how that bears on intent.
But account can be overdrawn for many reasons as opposed to account being closed. You do agree there's a difference in a valid account with insufficient funds and a check written on an account that has been closed?
I think it would really depend on the facts, whether there would be a distinction or not. I mean, I think you could have a case with insufficient funds where, the person knew just as well as they knew whether it was a closed account. So I'll reserve the rest of my time. Thank you.
Thank you. Hear from the appellee. Good afternoon.
Good afternoon, Your Honors. May it please the court. My name is Asa Edwards. I'm a Special Deputy Attorney General here on behalf of the state of North Carolina. I'd like to start out by just briefly discussing, in terms of the rule of lenity that was brought up, exactly what a thing of value is under 14-100 subsection A. In State v. Walston in 2000, this court observed that prior to the enactment of 14-100, prosecution for obtaining property by false pretenses required proving that the thing obtained fell into a specific category of thing. So in a sense, there were certain valuable things that you could be indicted for tricking someone out of, and things that you couldn't. But in State v. Walston, this court observed that by the enactment of 14-100, that rigorous distinction of categories was eliminated. And in State v. Brantley-Phillips, cited by the defendant in this case, this court found that other thing of value, the statutory language, was the most broad term one could define to include the category of valuable things.
Normally when something is stolen, the victim has given up something of value. Here, the victim, her position did not change. The debt or the obligation was still owed, notwithstanding the check, correct?
That's correct, Your Honor.
So how, if her position has not changed, she occupies the same position, how could she have accepted something that has value if she did not give up value?
Well, in State v. Brantley-Phillips, which is the case that I was just discussing, that was a similar situation where the defendant there paid fraudulent payments to the Department of Revenue, and those payments were subsequently reversed. So the state he didn't receive a permanent credit.
But in that case, there was evidence that at least for some period of time, the liability of the defendant was gone and or reduced or whatever by those payments. What evidence is there in this case that A, there was any liability, B, that it was forgiven or discharged?
I'd like to talk about the liability piece. I think it makes sense to start with the second part, which is evidence that it was discharged. It was a temporary credit. If Ms. Atcher is the creditor, she received the funds, deposited them in her account, and believed that that debt had been paid for a temporary period of time. During that period,
And when you say debt, what's the debt?
the debt is number one, as Judge Tyson mentioned, the case law in this state affirms that every parent has an inherent duty to provide for the care of their children, and that is a duty that arises when the child is born, not when a judge enters an order for a specific amount, and that's a quote. And
Was this for prospective child support, retroactive child support arrearage? What documentation in the record is there that this was, how this was to be applied towards a child support obligation? Was there any evidence of income, needs of the child, that sort of thing?
well, I think those are relevant factors, but the first piece of evidence is that the defendant testified that the money was for child support. But the bigger picture is that it's not material if it was a child support owed pursuant to a pre-existing order for child support, or a pre-existing duty and obligation to pay that could subsequently be reduced to a child support order for retroactive child support. In either case, this defendant had an obligation and a duty to pay for the care of his minor child. I believe that the offer of $4,500, the agreement reached by the parties, is prima facie evidence that that was an amount that the defendant could pay and that the parties agreed was going to be reasonable for the needs of the child. Of course, a court could reconsider that at a later date, but that doesn't change the fact that the duty and the obligation exists from the time that the child is born.
What do we do with the evidence that when they were hoping to cash this check or withdraw the funds immediately, the agreement was that he was going to retain some of those funds? That seems to undercut the idea that this was an agreement for $4,500 to absolve him of all his child support obligations here forever forth.
I think the answer to that, Your Honor, is that all inferences and contradictions are to be resolved in favor of the state in this appeal. And the defendant's testimony at trial was that this $4,500 was for child support. He did not concede that he was going to, if the bank cashed the check at the teller, end up trying to add on to what he was obtaining by taking some additional funds, which I believe Ms. Atcher's testimony did present competent evidence of.
He was charged with 2 felonies in this case, right?
Yes, Your Honor.
And one was on the amount of the check being more than $1,000, is that correct?
I'm not sure what the threshold was on the uttering a worthless check charge.
Yeah, it's 2,000, I think.
Yeah, it said in an amount of $4,500, and this is an amount greater than $2,000. So it must be the threshold of $2,000 is what makes the difference between a misdemeanor and felony, correct?
With regard to the charge that's not been appealed, the uttering a worthless check, under 14-100, the threshold is $100,000. And so what we're dealing with is anything of value from 1 cent up to $100,000 for the purposes of liability under 100 subsection A without the aggravated penalty. I'd like to maybe touch briefly on an argument that was raised by the defendant, the appellant here, which is that a contract cannot be, if it's for child support, is subject to some heightened be in writing, be notarized, be approved by a court. As an initial matter, the state's brief sets forth an argument that there was an oral contract that was supported by adequate consideration. The defendant has argued in brief that it would be illogical for $100 to serve as the consideration for $4,500, but as this court and our Supreme Court have held, even the slightest amount of consideration can be binding for the most onerous obligations. And in the case cited, Moyer v. Moyer, for example, which is distinguishable from the case here because there the father was not the biological father. And so what the court was examining in that context was looking in connection with 3 different statutes for separation agreements, for a provision of law specific to awarding child support against a non-biological parent.
So, but the allegation in this case is not that the consideration was $100. The allegation is that the consideration was forgiveness of a debt. What evidence is there that he was completely absolved of this debt, or even partially absolved of a debt?
Your Honor, I agree that that's a difficult question in this case because it was almost inevitable that the fraud would be discovered and that the credit that Ms. Atcher provided to the defendant for paying the $4,500 would be negated. However, there was a period of time where she was deceived into believing that that satisfaction had been satisfied, and in reliance on that, she spent her own time and money driving the defendant around town, taking him to lunch with her kid, allowing the child to visit with the father in her home until late into the evening. And then, if you don't look at the $100, you've still got, and then in reliance on that, she had insufficient funds and a penalty from her bank. It was eventually reversed, but I think even a temporary credit is a thing of value. And if we look at State v. Phillips, Brantley Phillips, there the court has held that whether a thing was valuable is properly determined by a jury, and a jury here, I think, was aware that it was a temporary credit that Ms. Atcher provided for that payment, and that it was something of value.
Was the jury given a specific instruction as to what the alleged thing of value was?
The jury instruction says property, and I don't believe the jury was instructed as to anything beyond that, other than.
Does that not raise a concern that if we can't articulate whatever the obligation was, that the jury might not have reached the unanimous verdict on what property was obtained? Was it the $100? Was it the promise of, part of the funds? Was this for child support? Was this for some other debt? Does that not raise unanimity questions?
I agree that it does raise some concern in terms of the reasonable certainty, but I think that threshold was met. For example, in Brantley Phillips, the defendant in that case was attempting to obtain multiple things of value through the false pretense employed there, and so it could have been multiple things in that circumstance. Was
there any request here by the defendant for any special verdicts or special jury instructions?
No, Your Honor, and that was what I was going to address next, which is this jury instruction was actually agreed to by the defense. And so to the extent there was any infirmity or lack of specificity in that instruction, it was waived and any error was invited. And so I don't think the defendant, they haven't raised it on appeal as an appealable issue regarding the jury instruction. And if they did, they wouldn't have been harmed by it because they invited the error by agreeing to it in the charging covenant.
But in the context of a motion to dismiss, it could go to a fatal variance type issue.
Well, I think that's why, if it had been pursued in that context, then there could have been a bill of particulars, or there could have been something addressed in the charging conference to handle that issue. The defendant sat on his hands, and any error that occurred was as a result of his own negligence or conduct.
Well, but the allegation in the indictment is pretty particular. It's $4,500 for forgiveness of a debt. That's what the state set out to prove.
And I think the state did prove that. I think that this is a situation where the false pretense was utilized to get $100, to come in and get some time and some courtesies and favors from Ms. Atcher, driving around town, doing various things. And if he had the opportunity to come and take some more money on the back end, I think it was an evolving series of transactions all arising out of the same false pretense on the same day.
So the fact that her position did not change, I know you talked about the revenue case. The fact that she occupied the same position before and after, I heard about the charges and the $100. She did put forth $100. How does the state respond to that?
I'm sorry, I'm not sure that I understood the question, but if it's along the lines of what Judge Hampton.
What loss did she incur?
She lost, if we're not talking about the $100 and we're not talking about the attempt to get something else and we're not talking about the overcharge, it's the temporary credit. I mean, I think you can look at her as a creditor with a ledger, and she placed credit on that ledger during the pendency of this fraud.
And what would you have the court to do?
Well, I believe that there was sufficient evidence on the issue of debt forgiveness. I don't believe that the jury would be forbidden from finding the additional pieces of this scheme of value. And so as a result, I think that the motion to dismiss was properly denied, and this court should affirm the trial court.
Thank you, sir.
Thank you, Your Honors.
Ms. Strickland, you have about 4 minutes. 3 minutes and 52 seconds to be exact.
I think that,
Oh, I think I have 52 seconds, but
There was rebuttal time, right? She reserved 3 minutes of rebuttal.
yes, but
so I'm happy to answer specific questions you all may have, but I think I want to go back to the point about
Let me ask you one thing to respond to counsel's assertion that the thing of value that was $100 that the victim did give up. I don't know if there's any evidence that she ever got that back. There was evidence that there were bank charges that were imposed for the check. There was evidence that there was time and money spent for her to deposit the check, to spend time. Would that not be consideration? Why wouldn't those all be things of value in and of themselves?
Well, I think, again, even if you assume that they are, I think you have a situation a lot like what Brantley Phillips is talking about in its discussion of the law in this area. If you have multiple things of value that are alleged or could potentially be proven, and some of them aren't proven and some of them are, you can't sustain a verdict under those circumstances because, as Judge Hampson said, it's at least possible that some of the jurors could have convicted on an insufficient legal theory. So I think that even if those things are I don't think they are. I think, as we said in our brief, this is essentially a normal day, a normal social interaction, and the issue here is whether there was a $4,500 debt that was forgiven. And I just don't think that there was any evidence of that. I mean, if you come back to the child support theory, the Moyer v. Moyer case, I think it's important. In that case, they were saying a non-biological parent should not be, in the absence of a written order agreed to by a court, shouldn't be held to a higher standard than a biological parent would be.
But in this case, your client's a biological parent, correct?
We know that now, but that was not even known at the time of the offense. It wasn't established until 3 years later.
And then on page 7 of the state's brief, it cites a quote that says, "It is a legal obligation that arises when the child is born, not when the courts order a specific amount to be paid."
Right, and I think it's really important to not overinterpret that language, because I think if you do that, then frankly, as I understand the state's theory, it would be so broad you wouldn't need any of these statutes at all covering child support. I think if you look at the first case cited in the state's memorandum of additional authorities, in re SE, it kind of proves this point, because this is not a criminal case. This is a termination of parental rights case, and there is a statute governing when a child is taken out of the home and put into foster care that the parent is supposed to pay for the cost of foster care. But it seems like under the state's theory, it should just be so obvious that almost there's like a common law obligation to pay child support. Why would that statute even be necessary? Why would you have the need to have a child support order in the first place? Somebody should just pay. And I think it's because you have to have a court. For example, we don't even know, in the absence of an order or a binding contractual agreement, how much was he supposed to pay? What did he actually owe? All of these things are complete speculation, and that's exactly the type of issue that takes it into the realm of a motion to dismiss for insufficiency of the evidence, because it's speculation, piling inferences upon inferences, And simply having to rely on unreasonable assumptions, like assuming that child support court had already taken place when there's no evidence based on this record that it had.
Well, I think one, the reasonable needs of the child is always the standard versus if it's either in a support order or when anyone's considering, and the ability of the parent to pay. Those are two of the factors that we always look at.
Yes, that's true, and I think that's why these types of matters have to go through a court. And without that, there is not sufficient evidence when we're talking about a criminal case and we're talking about somebody going to prison, being deprived of their liberty for not paying child support. It seems like there should actually be evidence of what was owed, particularly when the statutory presumption is there is no obligation to pay child support even under a separation agreement unless it's approved by a judge.
What would you have the court do?
I would have the court reverse the judgment on the attempted obtaining property by false pretenses.
Thank you.
Thank you.
Thank you both.
Thank you.
Court's going to be at ease for just a moment while the parties have a chance to move away from the table, and also we need to reset the computer equipment for the next case too. So we'll just be at ease for just a moment. Thank you.